the limited liability clause in your contract. What's it doing for you, and what is it not doing for you? Stick around.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. My name is Rob. I will be your host, and I apologize for leaning back and forth in my chair. I've got a new suit jacket on, and I don't know what they're called. Is it the vent? Like the flaps in the back? There's a thing. I don't know if I'm supposed to cut it or not. And so it's kind of causing me to like move around. Actually, that's if you are in the men's wear, the men's fashion portion of my audience, maybe it exists. I don't know. If that's what your expertise is, am I supposed to cut those things? I don't know. I used to work at a place, and my boss was a smooth French guy, and he would be like, Rob, if you have fashion questions, just do what James Bond would do. And it's like, that has never been helpful because I have absolutely no idea what James Bond would do in any situation. I'm probably closer to Larry the Cable Guy. With that being said, sorry, I digress, I guess. Anyway, great episode today. Short and quick, to the point about limited liability clauses. But before I get into it, please be sure to go to my YouTube channel, Wedding Industry Law, like and subscribe there. I'm just going to unbutton it. There we go. Just like and subscribe. I would greatly appreciate it. Anyway, limited liability provisions, limited liability clauses in your contract. I'm not talking about limited liability companies. That's a completely different topic. We're talking about the idea of limited liability in the terms of damages that is in your contract. If it's not in your contract, then hey, this episode is definitely for you. So a limited liability clause in a contract simply says something along the lines of, in no event is the vendor, you, going to be liable to the client for any lawsuit, action, arbitration, whatever the case may be, for breach of contract or whatever cause of action, whatever dispute, for an amount that is greater than X. Okay, so it's limiting what you would be on the hook for in terms of money damages in a lawsuit to a certain amount. The most common amounts that I see in this industry is going to be a fixed amount. So like $1,000, $2,000, $10,000. Even more typical is the amount that is actually paid by the client. So most of the time your limited liability clauses are limiting damages that you would be liable for to either a fixed amount or a fixed amount that is equal to the price paid by the client for your services. I hope that's not confusing. So either some arbitrary fixed number or what the price is for your services. Those are typically what the limited liability clause is limiting damages for. So that's essentially the point of that provision. Okay, it's letting the parties know beforehand what you are going to be on the hook for if that client wants to sue you for whatever reason. All right, so let's work through 3 scenarios. Okay, how this will play out and why these terms even exist. So the first one is what I would call the future benefit of the bargain. So let's say that you're a videographer, okay? You've signed a contract, and we'll just say it's for $5,000. You're a videographer, you sign the contract for $5,000. You are agreeing to video record the wedding, obviously, and then provide an HD video of the wedding to the client. So it happens a million times a day, right? Okay. So let's say for whatever reason, you couldn't perform. You don't have the video to give them. So sorry, Charlie. Better luck next time. I'll get you half off your next wedding. Okay. So obviously the client is a little peeved at you because they have no wedding video. So what if they sue you and they want more than the $5,000 that they paid for you, which seems fair. But what if they're suing you for $150,000 because they intended to use that video as part of their entry package to The Amazing Race or The Amazing Journey or whatever that's called, where the two people go traveling around the world? I don't even know if that's a TV show anymore. I never watched it. I say this like I'm some type of like connoisseur. I don't know. It's just I dig reality programming, and that's just not one that I ever watched. But anyway, they were planning to use that video to get into The Amazing Race, and The Amazing Race's prize package is $150,000, and that's what they're suing you for. You dig? So that's what they're suing you for. Now let's just assume that they would have got on The Amazing Race, and let's also assume they were going to win. They have a rightful claim against you for $150,000 because that's what their plans were. And you're like, well, hold up, man. I didn't know that y'all were going to enter The Amazing Race. Like, how am I supposed to be on the hook for $150,000 when I had no idea that's what you were intending to use this video for? So this future benefit of the bargain is one of the ways that a limited liability clause is likely to help you. It's basically saying, okay, even if you're going to sue me because you couldn't get on The Amazing Race, you are going to be limited to $5,000. So you might get a judgment against me for $150,000, but that judge is going to reduce it down contractually to that $5,000. So working around any type of unforeseeable future benefit that the client is expecting that might not be knowable to you is one of the I would say is one of the benefits of the limited liability clause. Okay, scenario 2, I would say this is what I call arm's length transaction. Okay, or there's no crying in baseball. So you're a florist, you are entering into a contract. We'll say it's $5,000 again, just for making this super easy. Okay. You are going to give, let's say, Queen of the Night tulips, black tulips, to a couple that are getting married. All right, $5,000, black tulips all around the altar. Okay, tulips come in. They are not as dark as the couple would have liked, and they are super goth, and so they're super bummed. They want to be forlorn on their wedding, and you are preventing them from being forlorn. And so they're pissed. They sue you. They sue you for emotional distress, among other things. They want damages for emotional distress because they wanted to have a super goth wedding and you made their wedding happy because the flowers were not dark enough for them. It was not forlorn enough. So I'll even throw this into like maybe it's the same concept where they were going to enter their images into Goth of the Week Weddings magazine, and they're not going to be able to do that. And so they're emotionally distressed. They're crying every night in their coffin before they go to bed. They can't sleep in their coffin. Again, the limited liability clause is essentially saying, this is an arm's length transaction. I am not owing you any type of superior duty. It's the same as if I was selling you rubber bands. Okay? No one would expect anybody that doesn't get the appropriate amount of rubber bands in a package to cry for 6 months or to get irritable bowel syndrome because they're so stressed out. This is an arm's length transaction that is just the same as any other transaction for widgets, and that's why we are limiting this to $5,000. So that's the second scenario that the limited liability clause kind of helps. It's essentially saying, I'm not going to worry about whether or not you're going to be suing me for emotional distress. We're all agreeing at the forefront that you're not going to do that. The final one, even though there's many examples I can give you, but these are the most common that I see in my experience. But the third one is what I call the domino effect. So let's say that you're a coordinator. Okay, you're a day of coordinator. Contracts for $5,000. You got to show up to coordinate the wedding at 4 p.m. or whatever, 3 p.m. Who cares? 4 p.m. Let's say that you're a half hour late. As a result of you being a half hour late, you cause all the other vendors to stay a half hour to an hour late. The band, the caterers, I don't know, whoever else. And let's say that tallies up to $30,000. That your contract for $5,000, but the client has a perfectly reasonable argument that they're owed $30,000 because you were 30 minutes late, which being 30 minutes late is a breach of the contract. So they're allowed $30,000 in damages. So this is basically saying, nope, if there is a domino effect caused by my negligence or caused by my inadequate performance, you are again limited to $5,000. You're limited to $5,000 if I cause the butterfly effect or domino effect. The butterfly flaps its wings and then there's a hurricane next Tuesday. It's not my deal. I mean, it is my fault, but I'm only cutting you a check for $5,000 because that's what you paid me, right? So that's another way of having a limited liability clause, which limits the amount of damages that you owe the client if you mess up to what they paid. Those are some pretty typical examples. What are the limitations of a limited liability clause? There are a couple. I do want to stress that these examples are jurisdiction dependent. Some states, some jurisdictions might not like limited liability clauses in the situations that I just named, and they'll blue pencil it or strike it through or even rip up the entire contract. Okay, so just understand that limited liability clauses are jurisdictionally dependent for the most part. Now, second thing is this. The limited liability clause is often not going to get you out of tortious or intentional conduct. And what I mean by that is you cannot walk up to the client. Let's say that it's the bride. You cannot walk up to the bride, punch that bride in the face with your brass knuckles, and then say, here's your money back. You can't sue me for anything else. No way, Charlie. That is absolutely not happening. A limited liability clause does not allow you to get away with criminal conduct, intentional conduct, or intentionally tortious conduct, or negligence or gross negligence for the most part, almost any time. It doesn't allow you to show up drunk, with your Natty Light, your Pabst Blue Ribbon, Colt 45, whatever you got. You can't be drunk, slap somebody around, throw up everywhere. You can't do that. That's the limited liability clause is not going to allow you just to simply write a check for that fixed amount or the amount that they paid you and call it a day. So there are limits. Now, again, most of the time where you're going to see a limited liability clause enforceable is going to be in those first three scenarios because those are typically breach of contract related as opposed to extreme negligence, intentional conduct, criminal conduct, wrongful conduct like that. It's typically will be more likely held up when it is about inadequate performance versus some type of independent wrongful conduct. Okay, so I'm going to leave it at that. Hopefully you found this episode informative. If you do, please share it. Let somebody know that you have stumbled across the most boring wedding and event related podcast in the entire world. You want to scream it from the rooftops. It will really help me out. Please head over to Wedding Industry Law on YouTube. You can actually go to weddingindustrylaw.com. It doesn't matter to me, but YouTube, I would love the YouTube gods to shine on me. So like and subscribe there. Like and subscribe wherever you get your podcast from. If you have any suggestions for content, please reach out and let me know. New episodes every single Monday, sometime in the morning. Depends on what coast you're on, I guess. And with that, we'll see you next week.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.